Public hearing with the Assisted Dying Review Panel, and we are speaking to the Minister for Health and Social Services today. My name is Deputy Louise Dublé. I am the chair of the panel. I'll let my panel introduce.
Yeah, Deputy Catherine Curtis, Vice Chair of the panel.
And our officer.
Ben Walker, Acting Committee Panel Officer, supporting the panel.
And Minister, if you could introduce yourself and your officer.
Tom Binet, Health Minister.
Ruth Johnson, Director of Health Policy of the Government of Jersey.
Thank you. So, yes, apologies for the late start. We've had some technical difficulties, but it should all be working now and being streamed live. And the recording and transcript will be available afterwards on the States Assembly website. Could everybody please check that their electronic devices are switched off or on silent? And when you speak, if you could state your name and role, but there's not many of you today, so we should be fine with that. In terms of the topic under discussion today, if anybody, it can be a difficult topic to be listening to and considering. If anybody does need any support with the content of the hearing, support can be accessed via the listening lounge on 866 793 and also Jersey Hospice on 876 555. We do have 2 hours for this hearing. Can I just check your availability, because we've started late because of the technical difficulties? Is everybody okay if we go over perhaps 10 minutes and we'll aim to finish by 1:10, because given the contents of this topic,
Just said if we could finish by 1:10, just gives me enough time to get to.
Absolutely, that's absolutely fine. Thank you. Okay, so Minister, the panel understands. Oh, sorry. Before we start, I just wanted to give apologies from Sir Philip Balash, Deputy Sir Philip Balash. He would have liked to be here, but he's attending a funeral. Otherwise, he would have been here with the panel. We understand that the States Assembly, due to the amendment that was brought in the previous Assembly, there must be demonstration that the quality and availability of palliative and end-of-life services prior to any assisted dying legislation coming into force. Please, can you explain how this requirement will be monitored, evidenced and highlighted in future government plans, as well as the strategy, the palliative care and end-of-life care strategy for adults in Jersey 23 to 26, in relation to demonstrating the quality and availability of the end-of-life and palliative care services?
I'm not in a position to detail how that work will be undertaken, but it is my understanding that £2 million was assigned to improve palliative care provision, and that if either one or other or both of Part A and B get passed, and it goes through the entire process, nothing can actually be enacted until such time as assessment has been carried out that palliative care is improved. I know this is something, like with most things on the subject, Ruth is going to know a lot more about the detail than I do, but Ruth, you might want to elaborate a little bit on that.
Just before we do, so in terms of your own personal assurances, what do you need to see to personally to be reassured that those provisions are in place?
Well, the very fact that that requirement is in place gives me some reassurance, and subject to the assessment that's undertaken being suitable, then I think everybody's been well served.
Could you just elaborate on the assessment?
Well, that's why I'm going to hand over to Ruth, because I at this stage, again, that's still quite a long way away. That's up to 3 years away if everything goes, if everything gets passed through. So that's, as I say, that's some distance away. I'm not quite sure. Has a process actually been yet defined as to how that will be assessed, Ruth?
So where we are, as you know, the States Assembly made the decision to invest an additional £2 to £3 million per year in palliative and end-of-life care services. And that money is underpinning the delivery of a new end-of-life and palliative care strategy that has been developed by a consortium of organisations, which includes the Jersey Hospice as the lead. That strategy, if it is not already published, is imminently being published.
It is.
It is published.
It's available, yes.
And what that strategy does is that strategy has a number of long-term objectives. And those long-term objectives include elements such as 100% of patients at home will have access to 24/7 model of palliative care. That 100% of health and care professionals working across the community and in the hospital and hospice will have access to educational sessions around palliative care on a monthly basis. It's also got other metrics in it which are about 100% of carers being supported through the palliative care experience of their loved ones. So the strategy is underpinned by a number of metrics. Those are obviously very long-term objectives. So what we are envisaging is at the point at which draft legislation is brought to the Assembly, that draft legislation will propose that the Assembly does not enact legislation until it has seen evidence that there is movement in the right direction against those and potentially other metrics which we will work on over the next 2-year period. Clearly, because the end of life and palliative care strategy is a long-term strategy, they won't have met all those targets by that point in time. But what we would want the States Assembly to be assured of is that there was evidence that there was movement in the right direction to improving those services.
That's helpful, thank you. And in terms of that assurance, what I'd like to understand, Minister, what level of confidence do you have that those things will be in place, short-term or long-term?
I have to say, thus far, a high level of confidence, and that's basically because I've been quite close to the process throughout, and as you'll see from the extent of the documentation, it's been a very, very comprehensive process.
And is this something that you will be keeping a watching brief on and monitoring as it goes along, given the importance of this to States members and the public?
I will only be able to monitor it for the period of time for which I remain a States member.
Of
but
course.
I'll probably be keeping a close eye on it aside of that as well, because as you know, it's something that's close to my heart anyway, and the job needs to be done properly. So it was of great interest to me before I came into the States, and it will remain so thereafter.
And how will States members be informed about whether the strategy and the future government plans, financing around the strategy, how will States members be informed about whether that support is adequate?
Presumably that will appear in the report at the time when the report is produced. As I say, we're talking some three plus years away.
Yes,
so,
I mean that's absolutely what we envisage at this point in time, is that when we bring the draft legislation will have an addendum attached to it, which will explain delivery against that strategy, achievements, and if it is identified that there needs to be any changes in strategic direction, because of course we are talking about a quite long time period here, and if there's any amendments to that strategy, that will all be set out in the addendum to the report and proposition at that time, so that States members can make an informed decision about palliative care provision.
Yes, go ahead.
Yes, from this report, I saw that most people want to receive palliative care in their own homes, but most people actually receive it in hospital. And so there will have to be quite a lot of movement over the next few years if there's going to be something that will adequately cover what people...
Yes, so absolutely, and that goes back to the fact that it's a long-term strategy. So in 2 to 3 years' time, I think, and I'm, I will hasten to say that I'm not a palliative care expert, but as I understand it, in 2 to 3 years' time, you will not see that aspiration realised for all people, but you will see a development on that journey and a positive development on that journey.
If I could add to that, I think if you ask somebody whilst they're well what they'd like to have as an ideal, and that would be to be treated at home, the sad reality is that an awful lot of people will end up in hospital taking, well, not an awful lot of people because the numbers are low anyway, but some people will suffer the misfortune of being in hospital when that happens, and it won't be appropriate for them to be at home. So I think the aspiration at the beginning perhaps might not meet what's available to you at the end of life.
Okay, so you've talked about that it's a long-term aspiration, but what information and assurances will States members have before the debate on the legislative provisions? Like what will they have to inform their decision on that.
On the 22nd of May.
By the time the legislation is being debated.
Well,
So what we would look at presenting to states members is we would be looking
By that group.
I don't know, have we got a formal review process?
that's a level of detail that I don't have available, but we can certainly provide it to you because it is a different group of officers, but also a large group of external partners who are responsible for that piece of work. So we can get that detail to the scrutiny panel.
Yeah, I think given the previous debate on this and the palliative and end-of-life care, the importance of those provisions being robust and being suitable, that came through quite strongly in the debate. So that's something that I believe states members would like to be kept informed on. So if we could have the extra detail on how that will be kept under review. And is there sufficient officer resource in place to make sure that those pieces of work are, I think annually at least, kept under sufficient review?
Well, you may have a further comment, but my understanding, we've got the resources that we need for the time being, and as with all of these things, as they develop, they have to be reviewed, don't they? Yes. So if there seemed to be a shortfall in resource, then that would be flagged up, and presumably further resources would be made available.
Is there a risk that the resources wouldn't be available?
Not to my knowledge, but as you know, there are always cost pressures. But I think one would, with this piece of work, if it gets to the next stage, it's going to require what it requires to be done properly. It's not something where I think cost cutting could apply. What
does it look like in terms of numbers of officers?
I wouldn't have that detail. Would you?
So do you mean numbers of officers reviewing the delivery of the strategy? So as per the previous question, the strategy working group is a cross-organisational working group. It's not just reliant on Government of Jersey officers. And in terms of the detail of how that group are going to monitor delivery of that strategy, I don't have that information available, but we can find it out and provide it to you.
Truth is that the resource will continue throughout the process. It will actually extend as we go through the process, as more people get drawn into putting the whole procedure together. So it's an ongoing cost. So I don't think it wouldn't be very easy to give you a precise, detailed timeline of when those costs will be incurred.
Okay, we have some questions in more detail around the areas of the strategy and the action plan. Some of them were marked as current or ongoing, and some were marked as not started. Are you able to give us any more information, or is that something we should seek in writing?
So I think you would need to seek that information in writing because we don't have anyone with us who is leading on the development of the end-of-life and palliative care strategy.
Okay, we will, I think, come back to those ones in writing then. Okay, do you want to go to number 4?
Okay, so the panel notes the possibility of placing a statutory duty on the Minister to provide palliative care and end-of-life care as part of the development of an adult safeguarding law. Please, can you provide more information about how this potential duty is being considered?
To be honest with you, 8 weeks in, I've gone into that process myself. I don't know if you have any further information.
There is a piece of active policy development work that's going on at the moment that's being led by a policy development officer within my team, which is looking at scoping the remit of potential adult safeguarding law. They are in the process of working out options for what the remit and the extent of that law would be in terms of the statutory duties that it will place on both the Minister for Health and on other ministers to protect vulnerable adults. And the extent of the services involved. So there are obviously clearly lots of different groups of vulnerable adults. So, for example, carers who are adults are considered vulnerable adults. adults with learning disabilities, etc. There are a whole range of different groups of vulnerable adults. So what that working group is currently doing at the moment is identifying where are the key groups of vulnerable adults who are potentially at risk, what is the current access to the services that safeguard and protect their interests. Should those services be made statutory, because at the moment most of them are not statutory, and what would the associated costs be with that? Now, clearly, people at end of life, by dint of the fact that they are end of life, would potentially be considered vulnerable. So that's an active, ongoing piece of policy work, and we would anticipate seeing that initial policy scoping process being finalised for consideration by the Minister in approximately about the next 6 months, for there then to be further consultation around what could be within a draft law, and obviously that would need to be costed because there are significant potential costing requirements associated with safeguarding all groups of adults.
Okay, thank you. So at the moment, key stakeholders haven't been consulted yet, then, have they not?
No, we're at the very initial stages of doing the preliminary kind of policy research development. Yeah.
And
So there's not been wider consultation at the moment. There will be wider consultation once that process has been stepped through.
And that was interesting about possibly services being made statutory. So can you give any examples of that?
You know, a little bit like the provisions that went through to protect children, where there was statutory duties placed on individual ministers and individual officers to protect children and to take certain actions. It would be an adult's equivalent of that.
Okay.
It's the equivalent of corporate parenting.
Yes. So it would be, and what we'd look at doing is we'd look at how we dovetail that with the arrangements for children as well, because we've made significant strides forward with the protection and safeguarding of children within law, and that is not reflected yet in vulnerable adults. So that's exactly the piece of work that we're currently looking at.
Sounds like a very big piece of work.
It's a very big piece of work. Yes, and obviously, so the very starting point of that is the question of how far do we go?
Just one more question on that. Actually, how will the risks identified and the responses to those risks be tracked and managed once confirmed through the risk assessment process? So this is probably something later on.
So the risks associated with what? Sorry.
So the risks and responses associated with this whole law that's coming into place.
Oh, so the adult safeguarding law or the assisted dying law?
The adult safeguarding law.
Okay. At that stage, because we're such a preliminary stage in the process, we can't provide that information. But we would be really happy to come and brief the panel on the Health and Social Services panel on more detail about that work and the progress that we're making.
Just a quick kind of political question, Minister. Do you think that a statutory duty should be put in the law in terms of adult safeguarding, along the same lines as children, corporate parenting?
Probably, yes. As I say, I'm not close enough to this to give you a completely informed answer. As I say, 2 months into the job, there's been an awful lot to get my head round, and that's why you'll find Ruth answering an awful lot of the very detailed points, and I wasn't even aware of that piece of work happening, in fairness. And that is off sort of into a very detailed area. So,
but from what you've heard today, you think
from
probably...
what I'm hearing now, that certainly seems to make sense. Yeah.
Okay.
But I'd really need to discuss that with Ruth and look at the cost implications and the wider implications before making a sort of complete statement on it.
Okay. Any more on that one?
No.
Okay, so in terms of the different routes within the proposals, and there is the route 1, which is for terminal illness. Could you provide some more information about the decision to specify neurodegenerative diseases in the proposals above any other diseases and conditions?
Was it specified above any other?
Under the proposals, life expectancy is 6 months with for someone who's got terminal illness, but 12 months for someone with a neurodegenerative disease. And that is a development from the original proposals that the states voted for in principle, and there are a number of clarifications and amendments to that original in principle decision, and this is one of them. And the reason why we introduced that is we've done a lot of research about the realities of how assisted dying works in other jurisdictions. We've spoken to practitioners in other jurisdictions, and most other jurisdictions, or many other jurisdictions, have some kind of life expectancy. And one of the things that was quite clear in those conversations is the practitioners were raising with us the particular risks of a 6-month life expectancy for people with neurodegenerative conditions, and that is because of the disease trajectory. So, you know, if you have something like muscular dystrophy, it is regrettably the case that your quality of life is going to diminish many, many months before you actually die. So hence, as a result, the proposal that for those categories of neurodegenerative diseases, only that have those particular challenges around quality of life, there should be special provision of 12 months made.
Yeah, and I think that's very well explained in the proposals.
As we said, that's not been prioritised, it's just been facilitated, isn't that right? It's, yeah.
Yes,
Yeah.
yes.
Sure, and were any other conditions or types of conditions considered for similar specific proposals? And if they were, why were they not included?
So what we did was when we were looking at the timeframes, we were looking at the conditions that resulted in assisted deaths in other jurisdictions. And the condition that most likely results in an assisted death in the case of someone who's terminally in another jurisdiction they're the cancers, which I think we would probably anticipate just in terms of population numbers. There was not necessarily any compelling evidence from the information provided to us in practitioners in other jurisdictions that 6 months was a particular issue for those cancers, but it was the neurodegenerative diseases that kept on coming up with their advice and recommendations was 6 months is potentially very problematic for this particular cohort of people.
So were there any other conditions other than cancer or neurodegenerative?
No, so there were. So we did look at a range of other conditions, and you'll have to excuse me, I can't remember all of them off the top of my head. But in terms of the information provided to us in other jurisdictions, those were the two key categories that I can recall, and it was only the neurodegenerative diseases that raised these particular concerns.
Okay, could we have that list of other conditions that were considered? Could we have that provided to us with any detail on the reasons why they weren't provided for? Thank you. Do you want to move on to that one?
Okay. Yeah. This is about life expectancy still. So can you provide more information about the differences in life expectancy requirement for neurodegenerative, I can't say it.
Degenerative.
diseases and all other terminal illnesses which include a 6-month life expectancy? I think you've said some of that.
Might have covered that one, yeah, sure. Okay, thank you. So in terms of route 2, the unbearable suffering route, there were some conversations in the ethical review around the inclusion of this route, and I think some differences in terms of the previous reports that had been published. And the ethical review advised against the inclusion of this route too. So I'd like to ask you some questions about that, Minister. In terms of the reasons that the ethical review gave, one of the words they used was the term ableist. Can you just outline what you understand that term to mean and how it might apply here?
To be fair, you're using a word which is out of context. I read that review quite some time ago, if I'd read the paragraph in which that was included, but I'm happy to talk about the principle of it and my...
Can I read the excerpt? So that it says it makes and reinforces an ableist judgment. So route 2 makes and reinforces an ableist judgment about the negative value of the lives of people with disabilities.
That's a statement made by somebody else, and you'd have to ask them what they meant by that. And I'm not entirely sure, to be fair. I can't really speak for someone else.
Feel free to take a moment to reflect on it, but it is important that you give your views as part of the hearing today. So I'd just like to understand your understanding of that term ableist and how it applies to...
Well, as I say, right, you've given me a paragraph, but I'd have to, if I'd have had time to reread everything before I came today, I'd have perhaps a little bit more of a view on that. But if could you perhaps rephrase the question in such a way as you're asking me my opinion on something specific, because I find that quite awkward.
This was one of the main principles from the ethical review about why they didn't support Route 2.
Well, if you can articulate that a little bit more clearly, I can give you my view. I'm not frightened to give you a view. I just want to have a little bit more of an understanding of what you're driving at.
Okay, do you agree with what the ethical review stated about Route 2, making and reinforcing an ableist judgment about the negative value of lives of people with disabilities?
If that means what I think it means, then I don't particularly know.
Could you elaborate on why?
Well, I don't. This is a matter of personal choice for an individual, and so long as there are sufficient safeguards everywhere for everybody concerned, I don't really see this as being an issue. I have to say, with regard to the ethical review, and I'll make my feelings a little bit better known, I read the biography of the 3 people concerned, and before I started reading their outcome, I guessed straight away what the outcome would be. And when I read it through, it actually was the outcome I expected. And I've gone public on saying that I think an ethical review wasn't perhaps the wisest of things to do, because you could have chosen any kind of combination of 3 ethicists and perhaps had a different outcome. It's the opinion of 3 people, and that's what their ethical oversight, what their ethical opinion happens to be. So how useful that is, as I say, if this is a free vote, it's a democracy. If people want to take note of that, and that informs them to the extent that they feel obliged to follow the ethical advice that's been given by these 3 people, that's a matter for them.
It might help at this point to reflect on the terms of reference of the panel. And the purpose of the hearing is to allow you to explain your political decision-making behind the proposals that you have put forward. So that should form the bulk of the hearing, and we will be going into details of some of the different documents that have been produced to try and understand various proposals and ideas that you've accepted from different recommendations or not accepted.
Which is fine. I'm very clear about this. All I'm doing is presenting the result of a process. I haven't interfered with that process. Part of that process has delivered an ethical review, and it's for democratically elected people to make of that what they will. I've made no attempt to try and remove it or do anything else. The process has delivered something that I think is very comprehensive and very creditable, so I don't have any issue with it. But I would just, you asked the question, I give you my view on that particular issue. That's just as an individual view, and each person that votes on it will be free to take their own view on it and attach whatever importance they see fit.
So today we are examining your views, Minister, not anybody else's, so that when States members come to make their decision on the day of the debate, they can examine all of the evidence. This is an opportunity for you to give in more detail than you might be able to in a speech. The rationale behind the proposals that you're presenting to the Assembly.
I have to make this clear if I haven't already, is that I hold my view as something separate, and my view hasn't informed the presentation of the proposals that I've taken the decision that those proposals should be presented as per the entire process. The process has delivered proposals, and that's the proposals that are coming through.
I wondered it might just be helpful if I just provide some factual information about the process of developing.
I'll just pick up on something the Minister's
Yeah.
just said. So if the proposals that are before the States Assembly are not your political views, Minister, whose are they?
They are the collective views of the process that's been undertaken on the government's behalf. I hardly think it would be appropriate for me to put a set of proposals forward that reflected my personal view. My personal view is probably reasonably well known because I was heavily involved in the campaign to bring this law forward. But I don't think it's my place to impose my views on anybody. As I say, the states voted to put a process in place. That process is run, and I, as the Health Minister, are putting the net result of that process forward for people to vote upon. Does that not seem appropriate?
Could I just say that part of that process included the ethical review, which did not recommend route 2. So there must have been a decision from you, presumably, to not
Yes,
go with that?
but the ethical review was part of that process.
Part of it, yeah.
It was part of that process. Yeah. And there was a recommendation from them to not recommend it. Well, that's what they've done. They've not recommended it, and that forms part of the presentation that comes forward to the democratically elected public. It's not for those 3 people to make a decision on our behalf. What we've done is we've included their opinion for people to have their own opinion on that opinion. I think that's relatively straightforward. And I think it's right and proper, to be honest with you. I think that's my duty.
Just so that we all have a shared understanding of our democratic processes, ministers are responsible for making decisions on the proposals and indeed own those proposals that are lodged
Absolutely,
in their name and
have any
have
problem with
political
that.
responsibility and accountability for those. And the scrutiny function is there to hold ministers to account for those decisions that are made. So we do expect that accountability to be in place and for those questions to be answered today.
Forgive me, but there's an implication there that I'm not answering your questions, or perhaps I'm not answering in the way that you want.
Ask the next question.
Yeah, go ahead.
Okay, so the next question, it carries on from what we're already talking about, which is what reflections can you make on the following extract from the ethical review, which is allowing assisted dying on such a basis creates societally endorsed and medicalised ending of life for disabled persons who are otherwise not dying, thereby signalling that a life with disability is less worth living and or more intolerable than a life without a disability. So this is a concern that's been expressed.
Yeah, I understand that has been expressed by a number of people in different areas, but I go back to the point that it's not for ethicists to decide how somebody wants to treat their situation. And I think a person with extensive disabilities has the right to determine for themselves. And I make the point again, and I hope I've made my point clear, but I'll do my best to make it again. We've had an ethical review. We've included the results, that ethical review, and the results and the recommendations in that ethical review for democratically elected people to take into account. Now, you might find 48 of those people say, absolutely, I agree with that ethical review, and I'll have no part in it. That's democracy. Or have I missed something?
No, that's helpful. So we got one of your views there that you had disagreed with the ethical review. That this is what we're hoping to draw out in the hearing, is your personal political views, Minister, and why the decisions have been made or not made, and what's gone into the report. Okay, it's this is the normal part of the scrutiny process.
I understand all of that.
Okay.
Just to sort of perhaps round this bit up, I'm not sure, lower perceptions of the quality of life of persons with disabilities are already commonly documented. So is there a plan to put in place in terms of training in order to mitigate this so that anyone involved in the process is not going to be thinking in this way?
Well, if you look at the process, it's pretty comprehensive, and it draws in people from all sorts of trained backgrounds. I have to say, I struggle to imagine how you could possibly have a process that's actually operable, that could be more comprehensive than the proposals that we have.
So you don't think there's needed any training to help mitigate this then?
Well, I haven't said that I don't think there's any training, but I would refer to the fact that we're dealing with educated, qualified people and a good mix of them that come into this whole process.
I wonder if the officer could state whether there is anything included in the training that might cover this area.
So absolutely there will be. So as set out in the proposals, there will be a detailed mandatory training programme that everybody who works in the Jersey Assisted Dying Service will need to step through. If the states were to determine that we should progress with Route 2, that mandatory training programme will include a whole module relating to disability awareness, to ableism, to underlying concepts and prejudices that may exist in life values. Mm-hmm. In addition to that, as set out in the proposals as well as mandatory training for people who are directly involved in the Jersey Assisted Dying Service, the oversight committee that's going to be established, that the Minister will establish as part of HCS, will have duties and responsibilities to provide guidance and to provide training to other professionals who, health and care professionals, who do not work in the assisted dying process, but who provide support and treatment and care to people who may request an assisted death. And one of the things that we would look at if Route 2 was to go forward is how to support additional awareness of ableist views being imposed on people with a disability and their quality of life. So we would look at it from both angles, both those in the service and other health and care professionals.
Thank you. Thanks. In terms of the ethical review, so the points raised about the ableist judgments about the negative value of lives of people with disabilities, we've covered that. There were some other concepts around the unbearable suffering route, and the ethical review raised the following points: that the concept of unbearable suffering was vague, multifaceted and subjective, and had that inherent subjectivity to it. So given those concerns raised, can you outline why the decision was ultimately made to continue with the Route 2?
I'll come back to my original point. We live in a democracy. We have the previous health minister, one person decided to call for an ethical review. Fine, we have an ethical review. They come up with a recommendation. It's the recommendation of 3 ethicists, and that's been included for the states, to the members of the Assembly to review and take a decision on that basis. If we rely on ethical reviews, why have we gone through this process? Why just didn't we have an ethical review for the whole thing and take the opinion of 3 people and rest with that opinion? And I'd ask you how you would feel if I'd have come along and said, I'm either removing it or altered the process that the states originally intended. Basically, we've gone through a complex process, and I'm presenting that as is.
So just to clarify the answer you've given, so did you disregard the ethical review in your decision-making process? Minister.
I'm not sure how I would have done that. I've taken full account of the ethical review, and it's been included for the elected members to make of it what they will.
Okay.
I can't see any evidence of disregarding anything. I accept that there's been an ethical review. I accept that they've reached their conclusions, and it's not for me to decide what the other 48 members decide upon. I've presented that for them because I believe that that's the democratic process.
So
I'd imagine you'd be very critical of me had I done otherwise.
So not getting to the debate just yet. So focusing on the period of time between the ethical review and the proposals that have been lodged. In terms of the decision making between then, what regard did you give to the ethical review before you lodged these proposals?
It's something that came up. I'm in danger of repeating myself horribly, aren't I? I looked at the ethical review and I thought, there we are. We've had the opinion of 3 ethicists. And I think it's appropriate that that should be included in the proposals that go forward for the states members to decide for themselves what they make of it.
And the points that they made about the concept of unbearable suffering being vague, subjective and multifaceted, what are your views on those points that they raised?
I don't particularly agree with them. I think this is a matter of personal, individual choice, and somebody shouldn't have a decision made for them because they become disabled.
Thank you. Thank you for giving your view.
I think people have a fundamental right, come what may.
Yeah.
I mean, I wouldn't want, because I become disabled, and that may well happen. I would find it patronising if somebody else came along and said, you can't have access to this because I've decided for you. And that's why I'll be very, very clear. It's about personal rights, and I hope that's clear.
That's very helpful. That's the kind of answer that I'm looking for in
Good.
terms of the
I'm
philosophy.
sorry if it took me a while to get there.
It's okay.
But
We
there
got
we
there.
are. I'm very happy to say that.
Okay. And in terms of the inclusion of Route 2, what are the main risks in including Route 2, and how do you intend to mitigate them?
Well, if you look at the required process, it's actually more elaborate than for Route 1 because it's got all the requirements of Route 1 plus a tribunal and a longer time frame. Like I say, having witnessed the amount of work that's gone into this, I think it would be difficult to come up with something even more comprehensive and yet still have it workable.
Can you comment on the concerns raised about the potential for the expansion of assisted dying in numbers and scope, and how this specifically will be mitigated?
Is this a reference to what other people tend to refer to as the slippery slope?
I think so, yeah.
I think in all the time that I've had an interest in assisted dying, I've had people sort of mentioning the slippery slope this and the slippery slope that. All I would say is whatever rules and regulations may come about, whatever laws come about as a result of this process, to have any changes to those laws would require precisely the same degree of care and attention that this has received. Mm-hmm. So that you within the provisions that will come through from this, if they do come through, I don't see there's any route for slippage. The only slippage that can occur is if somebody goes back to the Assembly and actually asks for things for changes, and those changes would have to go through the same rigorous process as we've already been through. So I personally find it something of a false argument.
Because I understand that this cannot be amended with regulations. It has to come back as another law.
So very specifically, the proposals do not allow for any regulation-making power. So every decision must come back to the States Assembly. And it might also be helpful for the panel to understand that in some other jurisdictions where there has been an expansion of the eligibility criteria over a period of time, that has sometimes been driven by the fact that other jurisdictions have hardwired into their legislation a 5-year review period. And it's that review period and the outcome of that review period which has resulted in an expansion of criteria. This legislation very deliberately doesn't do that.
Okay, thanks.
That's interesting. Could you speak some more about that, about the review period and why was that considered, and obviously it was disregarded, and why was it disregarded? Are there any other factors that were considered?
You'll have the details.
So we've done a lot of thinking around this issue of in developing the proposals, a lot of thinking around the issue of the slippery slope, and we've been very live to the concern that have been expressed to us by members of the public, and also very live to the fact that in some jurisdictions, not all jurisdictions, where assisted dying has been introduced, you have seen an incremental expansion of the eligibility criteria. When as officers we were set out on this task, one of the kind of like the guiding principles was you need to address to look at how your proposals address the slippery slope. So for that reason, as I said, we haven't included regulation making powers. We haven't included I think it was in Canada and one other jurisdiction, and I'm sorry, I can't remember which jurisdiction they included this review period. But the other thing that we have done is we have looked at the reasons why you see an expansion of criteria in other jurisdictions. Now, sometimes that is because those jurisdictions have made a decision, or parliaments of those decisions have made a decision looking at the kind of day-to-day working of their assisted dying legislation that needs to be amended. But in some jurisdictions, there's a very different reason, and Canada is often cited as the jurisdiction of concern. And one of the things that's not necessarily understood about the experience that they've gone through in Canada is that in Canada, they essentially have a kind of Bill of Rights, which has a right in it, which is a right to die. We don't have that in the European Convention for Human Rights. And what has happened is individual members of society have gone to the courts in Canada and have argued for their right to an assisted death, and argued that their legislation in Canada was too restrictive because it provided an assisted death for some people and not other people. And because of their Bill of Rights, their court has agreed with them.
Okay.
And also in Canada, the way that their legislative system is set up is very different. So essentially their Supreme Court can nigh on instruct their parliament to amend its legislation.
Okay.
So it's a very, very different
And those
setup.
risks don't exist
Those
in our
risks just don't
setup.
exist.
Okay.
You know, the European Convention on Human Rights is absolutely silent on a right to die. There is no right to die. So there is no point at which a person can argue under the European Convention on Human Rights that they have a right to an assisted death. They don't. They have a right not to be discriminated against, but they don't have a right to die to an assisted death.
Okay, so Minister, are you satisfied that any risks of this slippery slope happening, that any risks have been avoided or mitigated?
Absolutely, yeah.
Okay. Before we move on, in terms of the route to unbearable suffering, are there any other factors that you would like to highlight that influenced your decision to include that in the proposals?
Nothing that I haven't mentioned already.
Do you want to add anything else? No. Okay. So I'm going to move on to another aspect that was highlighted in the ethical review, and your proposals have been brought forward in line with the ethical review, and that's the age of 18 and over. So the decision was made to restrict the assisted dying service to people over the age of 18. So this proposed eligibility criteria, is it in line with other jurisdictions? And did you receive any views during the consultation period that argued the other way, to reduce that age?
In terms of the detail of the consultation that was received, I'd have to hand that over to Ruth.
Go ahead.
So when the states made the original in-principle decision in 21, they made the in-principle decision for over 18 and over, because that was recommendations of the citizens' jury. However, within the body of that report, for that report and proposition, we said that we would do additional consultation on this issue. We reached out to the then Children's Commissioner to have a conversation about how we managed a consultation with children and young people on such a sensitive subject. And we got a very clear steer back from the Children's Commissioner that it was the view of the Children's Commissioner that this subject was potentially so distressing to children and young people that the benefits of consulting them were outweighed by the risks of consulting them. So what we didn't do is we didn't do bespoke consultation with children and young people. However, we had young people who did attend some of our public hearings, and those young people held different views on whether or not children should be eligible to assisted dying.
Can you advise what age they were?
So when we go into public consultations, we don't ask them to give their age. But I am guessing that they were older teens, early 20s. So from about the age of 18 to 22, 23,
Sure.
around that kind of age range. They held a mixture of views. The key issue that was expressed by the kind of younger cohort of people who came to our public hearings was not about whether or not children should be allowed to have an assisted death. They were very focused on the principle of assisted dying for older people, and an awful lot of that was shaped by their own personal experiences, where they'd lost parents or they'd lost grandparents, rather than engaging with the issue of under 18s. We did, however, in the survey that we did alongside the public meetings, have feedback on this issue. And as with much with assisted dying, there was no clear consensus because there are a lot of polarised views about it. The majority of people who responded to the survey felt that it should only be available to people over the age of 18 because they were concerned about the issue of competency to make that decision, and also there was a concern about conflict between parent and children's relationships. If the child wanted an assisted death and the parent didn't, and actually what could be the consequences of that on those last few months of that child, potentially of that child's life. There is no easy or obvious answer to this one. It is one of those really difficult, nuggety policy issues, and which a decision will just need to be taken on. It is perhaps helpful to note that no other jurisdiction apart from Belgium and Netherlands permit assisted dying for under 18s. The Scottish proposals that have just come out talk about 16 plus, but there's no other jurisdictions at the moment that currently permit it for under 18s. And in Belgium and the Netherlands, there are lots of restrictions and caveats associated with it.
That background is really helpful, thank you. And you mentioned that it was a difficult ethical question. So, Minister, we'd like to try and understand your kind of philosophy and your views behind that. Can I just check that everybody understands what Gillick competency is? Could you explain, please?
So Gillick competency is a test that is undertaken not just by healthcare professionals, but also often by kind of lawyers and social workers to understand what the competency of a child is to make a decision, because obviously different children mature at different ages. So you may get some 15-year-old who would be, under the Gillick test, would be considered to be highly competent to make highly difficult decisions, whereas you'll get some older children who will be assessed as having lower competency because of their ability to understand, retain and process complex information.
So a judgment based not necessarily on their chronological age, but on the competency of their decision making. So, Minister, with this concept in mind, could you outline why proposals were not included for under 18s who could demonstrate this Gillick competency to be able to access assisted dying?
If I'm quite honest, I think Jersey is already taking a fairly major step in both A and B. And I don't think there's certainly not sufficient experience in any of this to be going into an area which is, as how did you describe it, Ruth, complicated, and you used two terms that I thought were
very difficult ethical area. Yeah.
Absolutely. This really is a very tricky area. I have to say, if I was 16 and a half, 17 and confronting a terminal illness and was in acute pain, I would feel aggrieved that the law didn't include me. But I think we have to have a starting point, a sensible starting point, and I think the one that we've got is probably as far as it was sensible to go at this stage.
Thank you. And is it fair to say that this, if there are areas that might be revisited down the line, that this might be one of them?
There are two key areas that are difficult: mental illness and below 18, and those are two very complex areas that may, at some point in time, come back onto the radar for further consideration.
Do you want to ask anything about this? Yeah. Okay, thank you for sharing your views on that. I think yours is the next one, yes.
So I have a question next about the consultation. I think it's ongoing or about to start with disabled people. So, Minister, the panel understands that targeted engagement sessions with disabled islanders will be undertaken with Enable Jersey and Acorn and the Jersey Employment Trust. Please give us some details of what this engagement will entail.
Well, I don't know what the actual engagement itself will be, but I think I very much support that process because I don't think it's fair. If people are feeling vulnerable, then I think they need to have special consideration. But in terms of the actual process, I'd have to leave that to you, Ruth.
So we have already undertaken engagement with disabled islanders because many disabled islanders, or some disabled islanders, came to our public meetings, but also we undertook targeted engagement working with Enable Jersey as part of our phase 2 consultation. But at that point in time, we were talking to disabled islanders around everything to do with assisted dying. And that included Route 2, but wasn't focused just on Route 2. And so a commitment was made in response to the recommendations of the ethical review that we did further targeted engagement with disabled islanders, very specifically on Route 2. And we are working on developing an engagement script with those organisations at the moment, which we will step through. And so that's not available yet, but we can certainly share it with the panel when it is. But the focus will be looking on those kind of critical key issues that you've already raised around what does ableism look like within this, and what, if Route 2 is to go forward, what do you think about that, and also what do you think the necessary protection should be to support you as disabled people who, as we know, are sometimes unfortunately dismissed by society. So it will be very much focused on that conversation there. It might also be helpful for the panel to understand that we, as I mentioned, we did consult disabled people in phase 2 consultation, and as with all groups of people, disabled people hold different views on assisted dying, including on Route 2.
Yes.
Yeah, so thank you for that. Do you have an idea of what proportion of islanders with a disability are going to take part in this later consultation?
Not yet. So it's all being worked out with Enable and Acorn at the moment.
Okay, and do you know what types of disabilities are included in the consultation to get a broad view of everyone's?
So we will. So we're working with them to make sure that we cover people with learning disabilities, with people with physical disabilities, people with sensory disabilities, and you may be aware that as part of the previous rounds of consultation, we've done kind of sign language videos to explain not all the proposals because that would be impossible to do, but to explain what it is that we're looking at doing. And we've done easy read versions. So we have done quite a lot of work to try and proactively reach out to people who will have a different view on these proposals.
Okay, thanks.
Yeah, I wanted to understand in terms of the timeline, because obviously there's a shortened timeline for these proposals being debated, and the consultation is happening, I think, at the end of April will be concluded, and the debate date is May the 21st. I would like to understand how that consultation is going to be meaningful in terms of having an impact. Could you outline what you will do with the information that you glean from that consultation?
Once again, it's not me that's going to be compiling that. That will be Ruth. So if you just go through the process, Ruth, because as I say, it is a detailed process, and that's beyond my sort of remit.
So what we will be doing is we'll be producing a feedback report report, a little bit like the feedback reports that we've done for other consultations, and we will be, and it will be published, it will be a matter of public record. It will be published also as an addendum to the report and proposition 2 weeks before the debate, and it will reflect back what people who participated in those consultations said to us around Route 2, what they believe the implications for Route 2 are on them and their lives and their decisions, and if Route 2 is going to go ahead, what they think should be provided for to protect them.
Thank you. And Minister, if disabled islanders conclude that they do not agree with the unbearable suffering route being included in the proposals, what action would you then take?
I think I'd have to wait and see what the nature of that decision was and what comes from that consultation process.
So, I mean, this is a hypothetical. So if the conclusion was from the disabled community that the unbearable suffering route wasn't acceptable to them, would you change any of your proposals? Would you make any late amendments?
Given that it's a hypothetical question, I'm afraid I'm going to reserve my position on that. I shall take a very close interest in that information when it comes through. I'm very happy to tell you what my thoughts are when it does.
Okay, so perhaps moving from any specific outcomes, are you minded to make any amendments, any late amendments at that date to take into account anything that is...
Something substantial and vitally important were to turn up, then that would have to be under consideration. At the moment, I'm not really expecting it because, as Ruth said, being disabled is being disabled. It doesn't prevent a person from having the same views pre-disability as post-disability, and I think we need to let those people speak for themselves.
Okay, anything else?
I just wanted to add, I think it'd be interesting to see as well from this consultation that those disabled people who want to have the right to assisted dying are not denied it for any reason as well.
That, I think, is an important point.
Sure. Okay, thank you. So I would like to ask about the multidisciplinary team and the associated assessment guidance. So the multidisciplinary teams will be formed, but the requirement and practice of those teams will not be provided for within the actual legislation. Could you just provide information to us about why that won't be in the legislation, given that it's a team will be formed for each of the assisted dying requests?
I'm aware of the formation of the team, but I'm not sure as to why that isn't included in those requirements, Ruth, if you can.
Yeah, so the law will say that there'll be a multidisciplinary team. It will place a duty on the Minister to ensure that there is a multidisciplinary team available. The reasons why the actual work and activities won't be described in detail in the legislation is because it will be entirely dependent on the person who has made a request for an assisted dying. So so for example, if there are concerns about potential coercion, you will need to engage different members of the multidisciplinary team with different skills. So, for example, more social workers who have more understanding and training within family dynamics to look at the coercion issue. If the person who's made a request has a communication difficulty, you would need to engage the members of the multidisciplinary team who have speech and language therapy support. So it's not defined because the activities of that team will be entirely dependent on the needs of the person who's made the request and on the requirements of both the coordinating doctor and the independent assessment doctor in terms of what extra skills, knowledge, etc. they need to be able to make a full assessment of that person and that person's situation.
Thank you. And Minister, are you satisfied that we have the necessary expertise on island to form these teams to make good, robust decisions?
In general, I would say, to the extent that I know, I would say yes. And I would have thought that if we really needed expertise from elsewhere, then we'd seek that expertise from somewhere else, would we not?
Is that possible within the scope of the proposals to seek expertise from off island?
Also.
Yes, the proposals are very clear, and this just isn't just related to the multidisciplinary team, it's related to everybody who works in the assisted dying service. Because there's a right to refuse to participate and people need to opt in to work for the service, and that would include the members of the multidisciplinary team. It may be that we either can't engage individuals with the right skills who are currently on island, or we can't engage enough of the right people with the right skills on island. So the proposals are very clear that in order to be able to stand up this service, the health department may need to contract non-resident professionals to come to Jersey on a contract basis to support an assisted dying request. But it's really important to note, if we do that, the proposals are very clear that that person must be registered with the Jersey Assisted Dying Service. They must have undergone the mandatory training and they must meet the competency requirements for that particular post.
Thank you. And one concept I would like to focus in on, which I think, Ruth, you raised, is that of coercion. And I understand that there are concerns amongst members of the public, and it was also raised during the previous states debate, around individuals being coerced into opting for assisted dying. And indeed, since that debate, we've also had the VOG report, the VOG Task Force report, which found that amongst support services on islands, there was an alarmingly low rate of understanding of what coercion looks like. How can you be certain, Minister, that the multidisciplinary team will be equipped to spot coercion where it does take place?
Well, as Ruth has suggested, some of those people will be people that are specifically trained or have experience in monitoring and identifying coercion. Given that you've got an initial doctor, a secondary doctor, and a multidisciplinary team available to them, I would make the point that I'm not quite sure how much further you can go to establishing where coercion might exist.
Do you have
My understanding is that from some of the anecdotal evidence that I've had, that coercion very often relates more to people being coerced into not taking an assisted death than to actually taking their life.
Do you share concerns of members of the public and states members that coercion to accepting or to accessing assisted dying, that there's a risk that might happen?
There's always a possibility, but given the complexity of the process, I think it's highly unlikely, and I think we do have. I'm very satisfied that those safeguards should be sufficient.
What evidence are you using to base that assertion that coercion is unlikely?
Well, my understanding is that in other jurisdictions, I became quite friendly with the principal director of Dignitas and had a number of conversations with him, and he said that I think he'd been involved in 300 and some odd assisted deaths, and he hadn't come across coercion in that time.
Given the findings from other reports that there is a very limited understanding of coercion amongst support services, do you think that perception that there isn't much coercion happening, do you think that's an accurate perception, or do you think perhaps there might be more there that is undetected in our community?
Well, I have to say, if there is, it's not apparent to me, but Ruth has done much more consultation than I have, read up a lot more. I mean, Ruth might want to make comment on that. It'll be a lot more of a qualified opinion than mine.
I think what I'd like to ask is that could you take a look at that concept and take a look back at perhaps the VOG Task Force report and expert views on coercion and ensure that it is included in the training in a robust way so that those professionals are equipped to spot it?
Yeah, that's fine. Yeah.
So coercion, there would be a dedicated module around coercion within the training, which everybody would undergo. I think
Can I just stop you there?
Yeah.
Could you point to where it would be? Because on page 241 of the proposals, where it outlines, it's Appendix 4, which outlines the training. I'm struggling, I may have missed it, but I'm struggling to find the specific area.
Let me just do a search and find. But just while I do that search and find, I think the other thing that it might be helpful to understand is that the law will provide a very specific duty on both the coordinating doctor and the independent assessing doctor with regard to coercion. So the law will say that they must be satisfied to the best of their ability that there is no coercion. So it is not that they can approve it if there is a lack of evidence of coercion. So it's the other way around. They must be satisfied. If they've got any doubts that there is potential for coercion, even if they cannot evidence that there is coercion, they cannot approve the request for an assisted death.
Okay. I think given that it doesn't seem to be highlighted as a specific area of the training, Minister, would you agree to take a look at the format of that training to ensure that it is included in sufficient detail?
I'll certainly take a look at it, but I'll make the point again that in any of these proposals, one has to eventually exercise some common sense and make a judgment as to looking at those proposals, looking at the safeguards and say, on balance, is that a sensible way to proceed? And I'm comfortable at this point in time that it is, but I will take up your point.
We could go to the questions about training. Do you want to do that now, or should we keep the order?
It's up to you.
So,
It's got more now on people, staff.
yeah,
Shall
okay.
I carry on?
Yes, go ahead.
Okay. So the panel notes that each assisted dying tribunal will be appointed by the bailiff and consist of one legal member, one medical member and one lay member. Please can you provide more information about the level of experience required of the medical member of the tribunal?
To be honest, I'm not familiar with that process. And Ruth, would you be able to help with that?
So the tribunal will be stood up through the Royal Court, and that will be a decision for the Royal Court to stand up as part of the tribunal service. But clearly, there have been kind of active and live conversations about the skill set that is required, but it would be a determination of the tribunal service as to the level of experience that they would require. But I have got no doubt that they would seek advice on that.
So there isn't anything set in stone about the level of experience, because I think there was some discussion around perhaps that the medical person should be someone with quite a lot of knowledge and experience.
You'll understand that I can't speak for the tribunal service, but I have got absolutely no doubt that they would seek to secure tribunal members who had demonstrable high-level experience within their field, given the sorts of decisions that they will be required to make.
Okay, because for the actual administering practitioner, they have to be a level 1 experienced medical person. So the tribunal doesn't have any requirements.
So what the proposals do. So I think this is. Sorry, please excuse me if I've misunderstood the question. What the proposals do is they set out at a very high level what the requirements will be for the people who are working in the service. Yeah. What the proposals don't do is detail what the requirements will be for the members of the tribunal, because that is a decision that will be taken by the tribunal service.
Yeah, so that's what I'm saying, really. So also the tribunal will consist of a lay member. So it's the same, there's no requirements of a lay member. The tribunal, apart from what the tribunal decides.
Yes, I've got absolutely no doubt that the tribunal service will develop those requirements at the point at which it was looking to stand up and recruit a tribunal.
I wonder if we should follow up those ones in writing, perhaps, actually,
Okay.
to
What we're saying
the
currently
bailiff.
is we put our trust in the tribunal service.
So the minister doesn't have oversight of
No,
that
no, no,
service.
that's, yes,
that's
yes,
the
yes,
service.
yes.
There's no
Yeah, yeah.
guidelines or
Yeah,
anything?
yeah,
Okay.
yeah.
Presumed
me to
capacity,
do this?
yes, please.
Okay, so now a question about capacity. Minister, the panel notes that the ethical review recommended removing presumed capacity, but that the final proposals include presumed capacity, so no capacity test when someone's applying. Please, can you describe the consideration that was given to removing the presumption of capacity and why the decision was taken not to?
Sorry, could you repeat that? It's a very detailed question.
Okay, so when someone's asking for an assisted death, it's just taken as for granted that they have capacity to make that decision. The ethical review said that the person should be tested to make sure they have capacity at that time.
I didn't realise actually that there's no capacity. Is there no capacity test at all?
so,
Ruth? It doesn't seem right to me.
No, so it's a little bit more complex than that. So, what the proposals say is that there will be a presumption of capacity, but if there's any concerns about capacity, that capacity must be tested. And that is absolutely standard with every other single piece of legislation. So, for example, our mental health and capacity law work on the assumption that there is, work on the premise that there is a assumption of capacity. So what is set out in the proposals is entirely in accordance with Jersey legislation, and actually is entirely in accordance with legislation within the UK about presumptions of capacity. So there's nothing unusual about it. But even though there is a presumption that a person has capacity, there is a very clear legal duty placed on the coordinating doctor and the independent assessing doctor if there is any concerns, fleeting, glimpsing concerns about capacity, and if they are not fully qualified themselves, because some of those doctors will be qualified to make capacity assumptions, they must, and it's a requirement of the law, go and seek a specialist who can undertake a capacity assumption. In addition to that, as set out in the proposals, it is envisaged that what the law will provide for is a capacity test against which a person's capacity will be tested, which is very specific to assisted dying and goes beyond the capacity test, which is currently set out in the capacity law. And so there's a belt and braces approach within that.
Okay.
Can I just... Minister, did you consider a compulsory capacity test as part of the proposals?
No.
You didn't. And why did you not give consideration to that element, given it was advised by the ethical review?
I'm sorry, I just simply can't answer that. Once again, it's a very specific question, and bearing in mind I had a relatively limited amount of time to apply myself to this. I trust a lot to what Ruth does, and I think Ruth has given a very adequate explanation of the situation in any event, which hopefully you're happy with.
Can I ask as well then, in other jurisdictions, is there no capacity test done in the same way as what's planned for Jersey?
A few things within that. So in terms of other jurisdictions, every other jurisdiction that permits assisted dying requires capacity. The law in those other jurisdictions takes a different approach to whether or not they have a specific capacity test or not. So there is, and this is often the case with assisted dying, in other jurisdictions there's very different approaches to it. But the presumption of capacity is a common feature in lots of other assisted dying laws. This particular recommendation of the ethical committee was, I think, of all the recommendations that they made, the one that we found to be slightly unusual. And one of the reasons being is because it's a basic human right to assume that a person has capacity until it's proved that they're not. Akin potentially to it's a basic human right to assume a person is innocent.
Do you agree with that analysis,
Absolutely.
Minister?
Yeah, I'm glad that Ruth's been able to explain it so comprehensively. I hope you're happy with that as an explanation too.
But related to that, I just thought it might be helpful to understand, because it kind of goes back to some of the earlier questions about Route 2, is the process in terms of making the decisions, that the proposals that have been put before the States Assembly. So there was a previous, so before Deputy Binet was appointed as Health Minister, there was a ministerial working group on assisted dying, which included the Home Affairs Minister, the Health Minister and the Social Security Minister, because they have a portfolio interest in assisted dying, for want of a better description. And this has just been a matter of timing. So it was those ministers who made some of those detailed decisions around how we progress with capacity and around the inclusion of Route 2 on the basis, and only on this basis, that it was in the original report, it was in the original in principle decision.
Thank you for explaining some of the political decision-making behind that. So, Minister, given that your officer has outlined some of the wider political accountability around this, have you significantly varied from any of the decisions of that group in the proposals that you've brought forward?
No, as you'll have gleaned from what's been said, I haven't had the benefit of participating in the 18 months' work, or 2 years of work, of any of those bodies coming up to this point in time. So in real terms, I've come to the party very, very late. So my intervention in all of this has been relatively low, simply because I haven't got the benefit of having had that inclusion in all of those processes.
So for the purposes of complete clarity, there was one outstanding decision on what went in the proposals. That was made after Deputy Binet was appointed with Health Minister. Everything else had been made beforehand. And that one outstanding decision was in the case of Route 1, where it says that the minimum time frame is 14 days. It was clarified to say, unless your life expectancy is less than 14 days, when there is no minimum time frame. That was a live issue that hadn't been resolved before Deputy Binet became Minister, and that is the one policy issue that has been resolved by Deputy Binet since he was appointed Health Minister.
That's helpful, thank you. So, Minister, have you read and understood and analysed all of the associated documents that would have been considered by that group in order to reach
Not
the
all of them,
agreement?
no, I haven't, no.
Which ones have you read and which ones are...
I haven't got a list. If I showed you the pile of documentation that I've been presented with over the last 8 weeks, I'd have to take a month off to get through it all. So I've had to get through whatever documentation I've been able to put my hands on that I think is relevant to the requirements of the moment, if that makes sense. I simply would have no chance of having gone through all of the documentation from all of the past. It just wouldn't have happened.
So, in terms of the area of assisted dying, which documents do you have a thorough understanding of?
I haven't brought a list with me. You have to forgive me.
Yeah, do you want to move on?
So you've mentioned about the training around capacity and so on already. I have a couple of questions now which are about the continuation of palliative care. So once someone is in the assisted dying process, can you advise what support will be provided for healthcare practitioners so that they can continue with the good palliative care until the end of life? So can you confirm whether any palliative care is only stopped at the point of administration of the assisted dying substance?
So, yes, the proposal set out, and this was one of the key underlying principles that are listed in the kind of the front of the proposals, that assisted dying is not an alternative for end of life and palliative care. It is an additional choice that some people may choose to make. So it is the case that the majority of people who will request an assisted death will be in receipt of end of life or palliative care. Lots of evidence that that's the case in other jurisdictions. That end of life and palliative care will continue throughout the whole of the assessment process and will continue up until the point that if their request is approved, the substance that brings about death is administered. So, so there's no disruption to that palliative care and end of life treatment. So it's not as if they're making an assisted dying request and then they're being kind of diverted down another care route. They are still actively receiving end of life and palliative care. And one of the things that it might be helpful to understand is that a person's request for an assisted dying is a private matter. So it may be that that person wishes their palliative and end-of-life care team to know about their request. It may be that they do not wish that, and that information would not be disclosed to that end-of-life or palliative care team without the person's permission or without an in-depth conversation with the person if there was any potential risks associated with the provision of care, with not disclosing that information. So, so that's how we'll ensure or work to ensure kind of ongoing provision of end of life and palliative care. The other thing is set out in the proposals, is that the professionals who are caring for people, understandably, because this is part of their job, often become very invested in that that person and can find it distressing if that person wishes to have an assisted death. So the proposal set out, and there is money made for, there is provision made for it in the financial resource implications, not only to provide counselling and support to professionals directly involved in the assisted dying service, but also in what we call, the other associated care professionals who will be providing day-to-day care for that person.
Thank you.
Try and move on now, shouldn't we? I'm just noting the time that we have left, and we still have a number of questions. So if answers could be shortened slightly, and we can always ask for more detail in writing. Minister, I'd like to ask you about the concept of the waiver of final confirmation of consent. How will signs of refusal or resistance be established if a person has been deemed to have lost their decision-making capacity?
There's another technical question that I think you'll have to ask you to help me with that, Ruth.
So we've had conversations with healthcare providers about this, signs. So where a waiver is being made, if a person was not consenting, the signs of consenting would be things like them turning their head away, or shaking their head, or saying no, or holding up their hands. So there are both verbal and non-verbal cues that the administering practitioner would be trained to recognise.
That was going to be my next question. Will that training be mandatory?
Yes, it will be. Yeah. All the training associated with this will be mandatory.
Thank you. Would you like to move on to 21?
Yeah, okay. So the ethical review recommended that professional guidance is developed to ensure that adequate efforts are made to ensure that assisted dying is a last resort. So please can you confirm whether the guidance developed in relation to assisted dying covers this aspect?
It does, absolutely does. Within the assessment process, both for the coordinating doctor and the independent assessing doctor, it is very clear that any decision to have an assisted death must be informed, and informed includes placing a duty on those doctors to make sure the person knows about and is informed about alternative care and provision treatments for them, so that there is absolutely no presumption that an assisted death is the right way forward for a person.
So they see what treatment is available in case they're not getting it at the moment. We couldn't see it in the forms and guidance section. No.
Apologise if it's not clear in that, or if it's an oversight. That is all it will be. They are quite dense at this stage, as I'm sure you appreciate. And as we come to the full development process, if there's any oversights or gaps, those will be picked up.
So in terms of that Appendix 3, the forms and guidance, are there likely to be additional forms and additional guidance documents that would be added to that?
Oh, absolutely,
Right.
absolutely. So as policy officers, it's been quite difficult for us. We have tried as much as possible to bring forward as much detail as possible, but to a certain extent, until the States Assembly have made decisions as to how they want to progress, it is a bit of a moving target.
Yeah. Yes, so in terms of that list of guidance, there is also the ethical review recommended that some guidance was produced to mitigate against confusion between the two routes. Can you confirm whether that guidance has been developed? Because we couldn't spot that in the list.
No, I have to refer to you, Ruth.
So it hasn't been developed, but it will be developed. There'll be very clear guidance on what route 1 is and what route 2 is.
Okay, thank you.
Will this be in place before it comes back to the Assembly then? So we've got to see this.
So what will come back to the Assembly is the draft law. I think that if the Assembly was to want all the guidance in place at the same point that the draft law is in place, that will potentially create some delays in getting the draft law forward to the Assembly. And also there are very real practical difficulties in writing guidance against a draft law. It needs to be an approved law, because if the Assembly were to make any amendments to the draft law, that would negate the guidance.
How will you manage that, Minister, in terms of giving States members enough information as to what the guidance will be, in terms of what Ruth
I have
has
to
said?
say, I simply trust Ruth as somebody I know that's put in an enormous amount, and as you can see, has a huge amount of detailed knowledge of this. And there does come a point, from a ministerial point of view, where you have to be reliant on your officers, and I have to say I have a great deal of faith in what Ruth is telling us, so I'm very comfortable with that.
Mm-hmm. Yes, I think you're lucky to have Ruth working on this policy area.
Yeah.
Do you want to?
So could you provide examples of the appropriate means of communication that will be acknowledged if a person cannot verbalise a request to withdraw? And I think you mentioned some of them already, really, so anything to add to that? Or?
So and is this just about the withdrawal of the request, or is this about the whole assessment process?
This is about them withdrawing, so they would have already agreed it and then they don't want it.
So that would be, so there'd be verbal communication, but also those non-verbal, so as I've mentioned, shaking of the heads, the holding up.
So it doesn't have to be in writing?
No, it doesn't have to. No, absolutely doesn't need to be in writing.
Okay.
Okay, that will be included in the mandatory training program.
Yes, yeah, absolutely.
Yeah. In terms of the training programme, we've asked some questions about that, and I think it's quite critical in terms of giving reassurance to States members. Can you clarify when the detail on that training programme will be available to States members, please?
In terms of timeline, and once again, I'll turn you, Ruth.
So obviously we've not started to develop it yet, because there's some really big policy questions that need to be asked and answered. We have had some very preliminary conversations with some of the professional oversight bodies in the UK who develop clinical training about whether or not they would be interested in being commissioned to do this work. We have had some provisional indications that they would be. We would obviously look to lots of other jurisdictions, so New Zealand, Australia, have got these really detailed training programs. So we have already got some indication that they would be prepared to share the detail of their training programs with us, so we wouldn't necessarily be starting from a blank piece of paper. But clearly, whatever we were training would have to be Jersey specific, because it would have to be specific on our law. I would anticipate that if a draft law was brought forward, whilst it might not have all the detail of the guidance, what it would do is it would contain a very detailed summary of what the training programme would look like, how it would work, what the modules would be.
Great, thank you. And Minister, is this something that you will be ensuring that happens?
Well, I liaise with Ruth as much as I can on all of this, so yes.
Thank you. So in terms of the Assurance and Delivery Committee, the panel notes that this committee would publish an annual assisted dying report. And one of the concerns flagged was that in some cases that could result in the identification of an individual, given the small size of our island, and that a decision in that case may be made not to publish some demographic details to protect that anonymity. Please could you provide some more information about how that decision would be made of whether to publish or not to publish?
Once again, highly detailed question that I would refer to Ruth. A lot of these questions, I have to say, are extremely detailed, and some, as you say, as you note from some of it, some of the decisions have yet to be made, so I'm not party to that.
My approach is always a thorough one, and it will continue
I can see that.
to be so.
Yeah.
So the first thing that we would do, and this is set out in the proposals, the Director of Public Health would be acting in an advisory capacity as to the information that should be protected. It should be protected into the public domain. It's also important to recognise that there is a tension, and to be transparent about the tension that exists with regard to information being in the public domain about an assisted death. And part of that is that we would not, through that annual report, want to disclose information which may reveal the identity of a person, or reveal too much about the identity of a person, because that's about respect and privacy. At the same time, it's really important to recognise that the registration process for the death registration process for someone who has an assisted death will in fact put into the public domain the fact that that person has had an assisted death. As with all, when a death is registered, this applies to all deaths, it has to be independently verified. There's a medical facts and causes of death certificate, which is completed by an independent doctor. That medical facts and causes of death certificate lists the cause of death and the ancillary cause of death.
And that's available to any member of the public?
So what happens with that certificate is the information is taken off it, and it is put in the records of death, which are public documents.
Yeah.
And what that certificate will do is, and this is just an example, it would, for example, say the primary cause of death was cardiac arrest or asphyxiation, and the ancillary cause of death, i.e. so one of the contributory factors to that cardiac arrest or that asphyxiation was whatever the name of the substance was. Yeah, or the fact that there had been a substance administered. Yeah. So it won't actually say there was an assisted death, but if someone wished to, they could find that information within the public domain. So therefore they could find out that that person had had an assisted death. This was a subject of a lot of consideration as to whether or not this information should or shouldn't be in the public domain. Different jurisdictions take different approaches to it. So in some jurisdictions, they just put the fact that the person had cancer. They don't put any information into the domain, into the public domain that talks about an assisted death. There are genuine concerns about transparency and openness around that in what is a service that rightly should have a good public. But also there's a concern that if Jersey, like other jurisdictions, some other jurisdictions, is going to permit for assisted deaths, we need to destigmatise that choice that people make. Needs to be a genuine choice that people don't feel fear or fear that they're going to be ridiculed or dismissed for making. And one of the ways in which you destigmatise things is you talk about it and you're open about it. So there is a tension between those two things.
Thank you. Minister, do you agree, or do you have any
Very
comments on the
comfortable-
rationale
very comfortable
there?
with that, yeah.
Okay, thank you. I think let's just go on to 28, I think.
Because we sort of had 28.
Oh, yes, go on.
Should we do 29?
Yes.
Yeah, so just a couple of questions, I could put these two together actually, about the administering practitioners, and we did touch on this before a little bit around the tribunal actually. With the practitioners with direct involvement in assisted dying will be level 1 doctors or registered nurses. Please can you confirm the level of experience in years required for them to undertake this role? And also there was a lot of feedback and consultation that newly qualified doctors would not be appropriate. So you could provide some response to that.
Yes, I can do, except for the fact, I'm really sorry, the detail has slipped my mind.
We could come back to it.
Yeah.
Because
Yes.
there's another area that might take us a while to get into. Yeah. So yeah, we can come back to that. And if we don't have time, we'll follow up in writing, I think. One of the principles within the proposals is the right to object to an assisted, the provision of an assisted death. And in terms of private landlords, can you provide some more information about processes that might be followed by an administering practitioner if the patient is in a shared accommodation and the owner of that accommodation objects to them having an assisted death?
No, to be fair, these are points of absolute detail. I haven't been part of the 2-year process. It's very specific. And are you able to answer that, Ruth?
Yes.
Very specific to me.
So it's proposed that the right not to participate is extended to premises owners. In most cases, we would envisage that being a care home provider. So where a person is in a care home, is a resident in a care home, and has requested an assisted death, that care home provider may object for a whole range of reasons, concerned about the impact on other residents, etc. But clearly it is the case that where people live in some form of shared accommodation, for example, a lodging house, it may be that the owner of that accommodation objects. But obviously, if it was a private rented accommodation with a front door, we would not envisage extending the right to refuse to object to a person having an assisted death within the privacy of their own home.
So that right to refuse to participate does apply to owners of care homes. Can you just clarify whether it applies to a lodging house, which is a private residence where no care is provided, but there might be multiple smaller residences within a house? Does it apply to that situation?
So we need to do, in terms of the law drafting instructions, we need to put some extra thought and clarity into the different forms of places where premises owners could object. If the states decide that people should be allowed to have an assisted death, of course it is desirable that people are allowed to die in their own home and where they live, and that will be the preliminary principle when bringing forward the legislation. But in respecting that preliminary principle, it has to be understood that there are collective living situations where it might not be appropriate. And what we need to do is we need to do more work to define what those collective living situations would be. It's also the case that the administering practitioner must make sure that the place is safe. So, for example, if it was a shared home and everybody in that shared home violently objected to that person having assisted death, it might be that the administering practitioner determines it's not safe for that assisted death to go on there.
Understood, thank you. And Minister, a political question now. Do you think that it's proportionate to allow care homes and nursing homes to refuse their residents access to assisted dying?
I have to say, listening to the conversation, that does raise some concerns for me, which I'm going to pick up at a later stage, because it's clear that somebody shouldn't be denied the opportunity to have an assisted death by virtue of where they live. So I will be having a discussion about where, I don't know if there are provisions for that.
There are,
If not,
so
no,
there are,
it's
so
fine.
yes,
So if
yes.
you want to go through those provisions, then
Yeah, so absolutely.
Very briefly.
So if a person was in a care home, the care home objected, then there would be a conversation with that person about an alternative venue. And sorry, venue's a terrible word, an alternative location.
Yes, yeah.
That would, the most likely place for that would be Jersey General Hospital, and there will be active and live conversations about an appropriate place in the hospital for assisted deaths to take place. So not on general
that's something
ward.
I'll take up.
Could you keep us updated on your considerations in this
Yes,
area?
I'm sorry
Thank you.
that it's been highlighted this late stage,
Yes,
but I think we
thank
need to make sure that we've got that properly
Thank
bottomed
you.
out.
Okay, so the law is intended to be silent regarding discussions with patients about assisted dying. Can you just clarify whether a healthcare professional can choose not to provide any information about assisted dying if the patient hasn't asked for it?
Sorry, just qualify that again. That if the patient hasn't asked for it, if
the patient doesn't ask for it, is the healthcare professional required to give any information? Ruth, would you like?
So the law is silent on it. So the law neither places a duty on a healthcare professional to provide information, nor does it prevent a healthcare professional providing information even if the person hasn't asked.
And if the person asks, what is the duty there?
And if the person asks, if the healthcare professional has a conscientious objection to assisted dying, and this is not a matter for law, this is a matter for the professional guidance of the NMC and the GMC and other professional bodies who produce extensive guidance on conscientious objection. What the healthcare professional needs to do, works for termination of pregnancy as well, is the healthcare professional has to say, I have conscientious objection to assisted dying, termination of pregnancy, whatever it may be. So I cannot provide you advice and support, and I suggest that you go and speak to X about it.
Yeah.
We will produce leaflets that
So they could be
healthcare
handed over.
professionals can
Sure.
just hand out for the assisted dying service.
Thank you. And the conscientious objection, I'd like to ask about the principle of direct and indirect participation. The panel member who can't be with us today raised some concerns about the definitions of direct and indirect and how they relate to other laws that do not have the words direct and indirect. Could you clarify, Minister or Ruth, as to what that actually means in practice?
Okay. So the other law in Jersey that has a conscientious objection clause, and of course we're proposing something much broader, which is a right not to participate rather than conscientious objection. The termination of pregnancy law does not talk about direct or indirect. Our termination of pregnancy law is based on the UK's old termination of pregnancy law, which also doesn't use the word direct or indirect. But there was a court case, there was a Supreme Court case in the UK that determined that the UK's termination of pregnancy law, and therefore de facto our termination of pregnancy law, only applied to direct participation because the application to indirect participation essentially was a veto to enabling women to be able to access termination of pregnancy. Okay? So we're modelling that Supreme Court ruling, and it's absolutely right that the words direct and indirect aren't in the termination of pregnancy law, but the principle of direct and indirect is established through a previous ruling.
And what would that look like in terms of the law, the proposals that we're discussing now? What would a direct participation look like, and what would indirect participation look like?
So direct participation would look like a person can't be forced to directly participate by being a member of the assisted dying service, by not being a member of the assisted dying service, but providing a supporting professional opinion or assessment. So a healthcare professional. So that would be examples of direct participation. If they were if an assisted death was taking place in hospital, a nurse from another ward couldn't be kind of pulled over to assist. That would be direct participation. A pharmacist can't be forced to directly compound the substance that's going to be used. Indirect would be, for example, an administrator booking an appointment for that doctor to meet that person over there. That would be indirect participation.
Thank you. And given the concerns about those terms being hard to define, will there be anything either within the law or within the guidance that will define those terms and what they mean?
So the interpretation to the guidance will define what the difference between direct and indirect is, and also there will be guidance that explains it in more detail.
It's helpful, thank you. Yeah.
Can I just ask, so for example, a care assistant working in a nursing home who may not want to take part in this, but would be normally going into that room and washing the person and knows them, would that be direct or indirect?
So the care assistant who is providing, any professional who is providing normal care to that person will continue to provide normal care to that person. They can't say, I'm no longer going to go to your home and provide you personal support because I know that you've requested an assisted death. Mm-hmm. So they can't withdraw their services on the basis that they object to that person's request for an assisted death. But what they absolutely can do is object to in any way being directly in participating within that assisted death. Mm-hmm. Yeah. So it doesn't provide for people to withdraw their support. In the same way, the GMC and NMC guidance, if a woman was to request a termination, the doctor can't say, you want a termination, therefore I'm not going to look at your feet or whatever it may be. Sure. They can't do that.
Okay.
Yeah, thank you. We have just some general questions for you, Minister, to end the hearing. And I think we've talked about the weightiness, both in volume of documents associated and in terms of the ethical considerations of this important policy area. What has been the most difficult decision that you've had to make, or the most difficult area that you've come across?
In the time, in the past 8 weeks since I've taken up the ministerial role, or overall, presumably you mean
Either.
just in. I can't really specify anything. No, I can't. There's nothing specific that I would say that stands out as being a real dilemma.
Okay, thank you. And why, in just summary, why are you bringing these proposals to the Assembly?
Well, first and foremost, because it's my duty. It's the will of our Assembly that this takes place, and I have, from a distance, followed the whole process and been very impressed by it. So that's why I'm expected to, and I'm happy to.
And why do you think it's important that the States Assembly gives this consideration? Because
that's the democratic process. That's the expectation.
Okay, Thank you for your time today, Minister.
If I can
and,
just take the
Officer.
opportunity to thank Ruth, because as you can see, she's got an immense amount of detail, which has been extremely helpful to all of us. And
Yes, that's
forgive
been
me for
evidenced
not,
today.
for not being able to answer an awful lot of those questions, but I think you probably understand under the circumstances it would have been very difficult. But
Is there anything
Thank you,
else
John.
you'd like to add before we close the hearing?
nope, not at all. That's fine. Thanks.
Some written questions, haven't we?
Yes, we do have some written questions that we couldn't fit in today, so we'll send those
Sure,
over
we'd
to
be
you.
very happy to answer them.
Lovely. Thank you
problem.
very
That's
much
great.
for your time
Thank
and
you.
for your expertise. Yeah,
Cheers.
thank you.